Is that okay? That's one of the main ones.
All right. Welcome, welcome everybody in the audience to this parallel session, which is the penultimate session of the day at the Translation Europe Forum here. I think in the back, is the microphone on? Hands up if you can hear me.
Yeah.
Many people hear me. Maybe you should go to the... No. Okay. All right, and welcome to the panel members, Eva ŠKORNIČKOVÁ, Annette Schiller, and Wojciech Wołosik. They will present themselves in a minute. I want to remind you about Slido. By now you know how it works, and we are certainly going to rely upon it for the discussions. Now, I know that the question that is on top of everybody's mind, and it's a question that I get asked a lot, and that is if amoebas, or amoebas as they say in English, multiply by splitting into two, does that mean that the first amoeba that ever existed is still alive? But that we won't go into that question, because we're going to discuss legal aspects of data in translation. So a couple of clarifications here. First of all, today speakers have been talking about data, but for lawyers, it's not one concept. Data can be the works, your translations, for example, the text that you translate from, which is regulated by private law in agreements, copyrights, but you also have the public law concept of data, like in personal data. And most discussion about big data is more towards this side. Of course, it's an interesting discussion that we probably won't come into, is when a translation segment, for example, goes from being works and when it becomes a data. This is a very complex issue. So most of the data in translation, if we call them data, is actually the works, copyrighted. It's copyrighted works. But as was mentioned by several speakers, not least by Lucas Vieira here, is that at least big agencies, language service providers, they actually have data too, activity data, workflow data, and other things. But a discussion about data in translation will become much more relevant if we see the bigger picture here, the notorious BIG, the big data. And we're going to speak also about that. But big data, the legal issues there include, of course, the intellectual property rights, industrial rights, mostly copyrights in the software, copyright in the processes and software may be patented, so there may be patents. Trademarks, trade secrets, we're still only in the IPR, industrial rights area. Then, of course, all the links in the chain are linked together with contracts, so there's contractual law. There will be liability clauses, forum clauses, deciding which country's jurisdiction has competence, confidentiality, non-disclosure agreements. We heard from the first speaker here today that competition law is quite important because, as we know, there are some data oligarchs that has lots of data and many people who have none. And then, of course, we have consumer law, and we also have public law in the form, more today, in the form of sanctions, which we have seen. So, to go through all these areas, we will need to sit here until the next Olympics, and we have 55 minutes. So we're going to have to focus on one area. And that we have said that we're going to start with the protection of personal data. And that is real data, and it's an issue that we haven't really gone into here today. But it's a hot topic because of the entry into force of the general...
Data Protection Regulation.
Yes, the GDPR. Okay. All other domains of law, you are free to ask questions. Use Slido. We will at least touch upon machine translation probably and translation memories. We had some questions from the floor earlier about confidentiality and IT security. We will try to look into that. I would like to mention also that Annette Schiller, who is the president of the FIT, Fédération Internationale des Traducteurs, they organize a seminar or a conference in The Hague, in the Netherlands, on the 23rd of November, which is dedicated entirely to intellectual property rights. Now, for translation, intellectual property, okay, all right. Now I would like to ask the panel members to tell us a bit more about yourself, starting with Eva, Annette, and then Wojtek.
Good afternoon, everybody. My name is Eva ŠKORNIČKOVÁ. I am based in Prague, so I am Czech citizen. And I am here, and I'm obviously very pleased to be here at this panel, discussing about the data and discussing about the personal data, which is one of the most frequent areas that we are talking about within the last 2 years. I am by profession lawyer, but the data privacy is not just about the legal side and about the legal aspects. It's also about the combination of the compliance within the companies. It's the combination of IT knowledge, and obviously the 1/3 of data privacy is obviously about the law. Just by curiosity, how many of you heard about GDPR? Oh, great. For example, in the Czech Republic, that was the most searched word on Google within last, at least 1 year, because everybody was talking about the new regulation, which, as you probably know, came into force on 25th of May this year. However, the law was adopted in 2016. So basically, there was a period of 2 years for all companies, including yourself, because you are obviously working and processing the personal data as well, to get compliant with this regulation. Based on the recent statistics, I can imagine that no one is really compliant, because it's quite hard to say what does it mean to be compliant. The law is here and it's enforceable just from May. And as you know, the regulators also just need to start a new way how to work together, because GDPR is regulation. This is EU regulation, which means that it's automatically implemented and valid and effective in each EU countries, and it doesn't require additional legislation process to adapt this regulation into each national legislation, like in case of any directive. EU doesn't implement or doesn't regulate various areas in the form of regulation quite often. But the reason why they decided, and I think it makes sense, and I am very happy for that, that they brought this law in the form of regulation, that it's very simple, because we are living in a digital world on the internet, and the data are just moving across the borders. And that's why it doesn't, it really makes sense to have one set of rules that would be implemented and that would be enforced in each EU country. All right. Okay. So I can talk about GDPR for hours. So then I will just pass the word to my colleagues.
Okay. Short introduction then. Annette Schiller. I'm a freelance translator for German to English. I'm Irish and based in Ireland again. I also teach on the MA in Translation Studies at Dublin City University. Have done so for the past 20 years. And I'm the current chair of FIT Europe, which is the regional centre of the International Federation of Translators. We have 59 member associations across Europe, not only in the member states, but outside of in Norway, for example. And we represent 40,000 interpreters, translators mainly, interpreters and terminologists. FIT Europe, as regards the GDPR, we've been encouraging our members to encourage their members to embrace it, to become aware of it, to be compliant. in an ideal world, they all are at this stage, but that's an ideal world. We had intended holding some kind of a conference or a workshop prior to the 25th of May, 2018, but we considered that probably it wouldn't be as straightforward as it all seemed. And we'd waited for a year, so 18 months, see what happened, and then come back to our associations and then run a conference where we can better inform our members.
Hello, everybody. My name is Wojciech Wołoszyk. I'm a lawyer linguist based in Gdańsk, Poland. I'm CEO of LSP, providing EU bodies and Polish public administration with legal and financial translation services. I also run my own legal practice, which specializes in different aspects, legal aspects of contracts in the translation industry and generally in professional services industry. My field of interest is mainly focused on intellectual property rights in the translation industry, also including legal aspects of data protection, translation memories, protection, legal protection, and legal aspects of machine translation. That's all. Thank you.
All right, thank you very much. So I'll throw the ball to Eva with the question, personal data, what is it? And why is it relevant to freelancers, language service providers, academia, students, the people we have in the room here? GDPR, why should they bother?
It's a funny question because everybody is just, tries to ask, what really its personal data is. GDPR says that personal data is any information that is connected to the person which can be identified. So if I just put it in very simple example, if you don't know my name, if you are not able to connect any information to me, then, for example, the size of my shoes will not be personal data. But in case that you have more information about me and you are able to get them, so you have tools to basically collect as much as personal data that are identified me, for example, my name, it still doesn't necessarily have to be personal data because my name can be used by some other person. But in case that for example, my address, or if you know my passport number, then obviously you get me. You get my personal data, and then you are obviously obliged to follow, the GDPR regulation. GDPR also makes a difference between the general data and so-called sensitive data. These are the data of special categories. And these data, these special categories of data, are very important for you because they are much more protected according to GDPR than the general data, which are usually available from the public registers, from the social media, for example. So the data like email address, phone number, name, obviously you don't have to pay so much attention and you don't have to be cautious, in case that you are somehow working with these data. But if you will have access to my health record, for example, or if you will be able somehow process biometric data, then obviously you have to be really cautious because the breach of the protection of these data will be penalized from GDPR perspective much higher than, for example, the breach of these general data. So in case that you are the translators from the specific industries, like, for example, health sector, or if you are translators of the sector where you obviously have access to various data, like, for example, localization data, or if you are translating whatever it's, connected to the biometric data, then obviously you are as I said, before, you have to be cautious.
May I ask, can you explain a bit more? If a freelancer receives a translation and in the text there are a couple of names, I suppose that is personal data, but the freelancer or the LSP can just go on, create a translation memory with that and translate it and send it back, or will they have to take any measures to protect that personal data?
If it's just on the level of this general data, I think that you don't have to invest into some very sophisticated tools to protect these data, because obviously, as I said, the names, email address and the phone numbers are usually available on my social media, for example, or on my website, for example. So, but still, you might have in connection with these, purely personal data, you can obviously have access to another set of information, and you always have to look at on what you are translating and which data are available to you. How I, as a data subject, as the owner, the person who to whom the data belong, how can I be harmed in case that someone steal, for example, the documents that you are translating for, whatever reason or purpose. So I always, try to make a comparison like to the tangible assets. If you have a jewelry, if you have a very valuable jewelry, if you have paintings, very expensive for millions of dollars, for example, you would probably will not put them on some free zone. So you always have to think about the data, what you are just having, and what might happen in case that, they will be misused. And I think, in case of this, tangible asset word, we are always trying to put some additional security protection, and implement the measures in order to defend, this property or defend this, tangible asset. And this is exactly the same with the data.
So Wojciech, if the translated text, which contains names, or if you use machine translation, online machine translation, for example, to translate the text where there is personal data, for example, names or other information, what will happen if this goes to a cloud? If it just goes to online to machine translation provider, what happens with this personal data? Is it in there somewhere?
Yes, there is. And we should start from making a clear separation, because we cannot treat the machine translation in terms of personal data protection as a whole in general. Something different is machine translation, internal machine translation software and hardware used by big players, LSPs, which is based on their internal IT structure, which is properly secured from unauthorized access of third parties. And something very different is using machine translation tools which are available online. And here we also should make a separation and underline the difference between machine translation tools which are free of charge, meaning Google Translate, for example. And it's quite clear for everybody that Google Translate it's not a very good solution for professional translator to use for treating any, processing any texts which include personal data or confidential data. But in case of DeepL, for example, which is one of the best machine translation solutions on the market, in my personal opinion, nowadays. I use it sometimes for my private purposes. It has two different versions. One is free version online, and the second is DeepL Pro, which can be used as it is as an API version, which stands for Application Programming Interface. It can be used together with Trados, and it comes very. It's very popular among professional freelancers for translating confidential and texts including personal data. And here you should be very, very careful, because I was thinking about introducing this solution to my own LSP, but I analyzed terms and conditions of this service, the professional version, and privacy policy, for example, and DeepL clearly says that you may not use our translation service for any texts containing personal data of any kind. When you go through, this is privacy policy, and when you go through terms and conditions in details, there are other provisions which make it very doubtful, let's make it like this, to use this solution for providing professional translation service covering confidential and sensitive texts. So when you would like to use machine translation for dealing with confidential and sensitive texts, including personal data, you can feel safely, your clients can feel safely when you're using internal solution, which is based on your internal IT software and hardware, which is properly secured, which is compliant with GDPR requirements, then that's okay. When you are using any machine translation online, also the paid versions, the professional versions, then there is a serious danger that you will be treated as non-compliant with GDPR and infringing your confidential clauses and personal data processing clauses in your contracts with your end clients and or your LSP being your contractor, your partner.
Okay, thank you. Here, Wojtek talked about something that we had a question earlier from the floor about confidentiality and secure systems. And as a consumer, of course, it's your first duty to read the conditions of use, the terms of use, because there the provider, the machine translation provider, should in principle explain what he or she, what they are going to do with the data. So that's the first stop. That's why, for example, in the Commission there was a general prohibition on using Google Translate, because in that, in the early days at least, the terms of use said that everything you put in here will become the property of Google, and we can do anything we want with it. And which is also what it said on the Facebook sites, etc. So first, check the terms of use. And we will talk about IT security in a moment. I just wanted to mention in this context that there is also a responsibility for you to make sure that you know what you're using. Now, Annette, what have you heard from the shop floor, from translators, from your members? What do they worry most about in this?
I suppose there are a number of areas that have impacted freelance translators. One is the area of bureaucracy in connection with retention of data. There are generally two situations where translators would retain the source document along with the translation. One is if they're certified translators or sworn translators in some jurisdictions, and the client receives a hard copy with certifying stamps, etc., etc. Very often you need to be traceable, which is why you have your contact details, your telephone number, your address, etc., etc., stamped onto the certified translation. So it needs to be traceable in case the document goes to court at a later point in time. Normally we hold on to the original document so we know exactly what we've translated to make sure it's correct, accurate, etc., etc. The second situation is, I think most or maybe not. Most translators will often hold on to the source documents. They print them off, or maybe they don't print them off anymore, but we hold on to them. And if these are contracts or have other personal data in them, the question is then, if we hold on to these documents, the source and the translation and the translated birth cert, etc., are we in compliance? Or are we not? Or do we have to get back to our clients each time we do a translation like that and say, listen, I need to retain this, I need to keep this, or I might need to keep it under some ISO standard? What is the situation under law?
Please,
what would
Eva.
you recommend?
GDPR is obviously based on certain principles, and one of the basic principles is data minimization, which means that we have to really just process and to keep the data for the reasonable period of time. And once you lose the title or the reason, the purpose why you should archive, the documents that contain obviously the personal data, then you have to delete them. Because based on the recent experiences and many companies, especially the companies providing the cloud services, for example, they store the data and the documents for ages. And obviously, some of them they don't even know that they have. They don't use them, they are not accurate, because one of the other principles of GDPR is accuracy, meaning that you always have to just work with the data that are accurate. If I just take an example, for example, the CV, if you have a CV of your employees, if you have a CV, for example, of the potential candidates, there are new rules for how long time you should keep the CV, because even the data in CV are getting older, because the people are changing positions, people changing, for example, phone numbers, emails. So you can't keep these documents forever. However, you as a translator, especially if you are translating some official documents that are the subject of some legal, regulations, or are the subject of the retention periods, then obviously you have this, legitimate interest and the title to keep them as long as, for example, the retention period of, will expire. And some of the documents, for example, in the employment area, connected to the labor code, for example, in many countries, the retention periods are more than 30 years for certain documents. So that's why you don't have to worry about, not fulfilling and not being compliant, with the GDPR with respect to archiving. But on the other hand, you should not keep the data that you really don't need. You really don't have a reason, purpose why you should keep them.
And how about the translation memories you created when you translated this text? Can you, when you use this translation memory containing the personal data, I suppose it's a form of processing. And in that case, would you need to notify the data subjects every time you use the translation memory? I hope not.
I would just need maybe to explain transaction memory. What is it? What do you mean?
Wojtek, please.
Yes, this is issue of general contradiction between our industry standards, technology requirements, and GDPR regulations. Because the first contradiction I was thinking of was between, for example, ISO requirements, which requires LSP or any translation company in translation professional who is certified to keep the translation, to make it possible to track the whole translation process. And as in the context you mentioned, it can be treated as non-compliant with GDPR requirements. Keeping personal data in translation memories is other issue, which I don't think there are good solutions and good answers to this question, because anonymization of data is one possible answer, but taking into consideration the daily conditions in the industry, only big players are able to anonymize data, text, documents. Most of the industry, which includes freelancers working directly with the end clients, or medium or even big companies, they are not anonymizing anything, and on a daily basis, I think they are violating GDPR. Translation memories are also very interesting from the point of view of intellectual property rights, because this is issue which I was analyzing very deeply, and it differs from jurisdiction to jurisdiction, but in our European standards, European regulations, there are two possible bases of protecting translation memories and potentially conflicting rights to translation memories, which are copyrights and sui generis protection resulting from EU directives. And in that context, transferring translation memories, including data, personal data, confidential data, and also including covering intellectual property rights of different players, of different participants of the translation process. This is very complex from the legal point of view, and our current legal regulations do not give clear solutions for all of that.
But if I just may, if I understand correctly right now what what you just explained about the translation memories, it's the same like with any other information tool you are using for your everyday purposes, like SAP system, for example, used in many companies. They also had to make
a what?
SAP, which is the system for the basically for the governance of the financials within the companies. It's very heavily used system in big corporations. And for example, due to the GDPR and the data minimization request, they also have to change some modules or add the modules that will enable companies really just to delete the data that you are not only using, but you really should not have them, because there is no reason, there is no title why you should keep them. So for example, if your employee will leave the company, so you will immediately should delete some data that that are not necessarily have to be kept or archived in your system. So you will keep only the data that the law says that you should keep them. So as I said, each EU country has a labor code, and each country has these regulations that explicitly say what kind of data with respect to your former employees you have to keep. So the systems, the information tools that you are using should be compliant with respect that they should provide you with the feature to be able to delete them. And there is a huge impact on many information technologies that they have to change the feature, they have to change the settings of these tools. And I think that that's going to be exactly the same for any tool that it's provided for the translation memories. So why the translation memories should keep the personal data? For what? Because if I translate my personal data, so my personal data means the data that are really just connected to me. So that's the big challenge for all these providers and the vendors.
All right. I'm going to ask whoever is going to do it to put one of the polls here on the screen, the one about am I GDPR compliant? It would be interesting to see how many of you are. And also, I would like to see if there are any questions from the floor. There is. Please.
Hello, I'm an owner of a linguistic company. I'm also a sworn translator. And my question relates to data transmission. Let's say I do not retain the translated document. I tell the client in advance that yes, we're going to do the translation in-house. We're going to delete it upon transmission. I'm going to delete also the email in the attachment of which I send the translation. Am I in compliance? If I use, like, for example, like Gmail platform, of course, to send the email with the translation attached, but I delete it. So is it no longer my responsibility, or have I done everything? Because there was a question about encryption and how many translators use encrypted software. And that's what I also am interested in. If I, as a translator, have now obligation to transmit everything I send in an encrypted form.
I think that would be the best solution how to get GDPR compliant, to be honest, because you will.
I agree. I mean,
Yeah. No, and that if it's allowed to you according to your business and the regulations, that regulate basically your business and the laws, I think that would be the easiest and more, the safest way how you will basically almost get out the scope of GDPR, because you will automatically transfer all the responsibilities to your clients, because they are obliged, to keep these documents, and they are obliged, obviously, just to also protect the personal data that are the subject or in various documents. So,
yeah, but what about its transmission, the act of transmission, the act of sending translation through Gmail? That's what I'm interested in.
yeah, there is a very good, we can talk about the Gmail for many, hours. Obviously, it depends what kind of Gmail you use. If you use a free Gmail, so obviously it's not secured, because, as I always say, whatever is for free, it's not the best solution. You are always the subject of sale. Look at the Facebook. We are able to open, the Facebook accounts for free, and Mr. Zuckerberg is one of the wealthiest persons in the world. How come?
Actually, the Gmail is the platform that my company domain runs on. Yeah. So I pay for the domain name, but it's based on Gmail technology. So it's not like my name at gmail.com that I'm sending translations from, but still my company's domain is based on that platform.
But it's fine, because you are using the Gmail or Google as a owner of the Gmail tool as a platform for transmitting your data. But if you are paying to Google for G Suite, for example, platform, that's another story, because they already implemented, security.
Sorry, so the responsibility is theirs to
because
secure
different
the
terms
transmission.
apply. Different terms apply. In case of free solution,
Yeah.
they are looking at everything. They are using your data. In case of paid service, we hope they not.
It's the responsibility. Where is the transfer of responsibility from me to another party?
There is a responsibility of Google. There is a responsibility of Google, because from the GDPR perspective, they are so-called processors. They started, investing, quite huge of money to getting compliant. Obviously, they are not compliant because we know what they are doing. However, in terms of these tools, I tend to believe it is the same like with Microsoft. it happened with the Office 365 tool as well. They invested and they had to, otherwise they will not be able to provide these services to the clients because of GDPR. Because if you use their tools, then they have to assure you that the data at least used through the paid licensed product should be safe. So then obviously you have the processing agreement, which is required according to GDPR, to have a processing agreement between you as a client and between the processor, and there should be really just terms who is responsible at what stage in case, for example, the transmitting, sending the data. But again, there are some other companies providing safer tools or encryption, for example, but it's upon your decision. And this is upon your responsibility, what kind of tools you will implement, and obviously you will invest in because of the data you are having and you are processing. So this is your value.
Yeah, but the investment cannot be disproportionate to the money I have available to make it, because freelance translators don't have or cannot invest disproportionately to what they're getting paid.
I understand you.
Can I pass this question to Annette? Do you feel that the investments that smaller companies and individual freelancers that they have to make to comply with GDPR is too big?
Well, yes is the answer. We feel that GDPR was originally intended for the big guys, whereas the small guys are the ones really being impacted incredibly. Even from a point of view of getting advice as to how to set up. I was talking to a Greek colleague the other day, and the Greek lawyers are charging €700 for advice on how to be GDPR compliant in a country where the average monthly wage is between €800 and €1,000 a month. So yes, it's in inverse proportion to the income. And very often the advice is not, we don't know yet because it's so new. You get a different answer no matter where you go, different member state, there seem to be different rules. We had, for Fit Europe, we've done our privacy policy or document and all the rest of it, and because we're registered, or because Fit is registered in France, it went to a French lawyer to be tested, and we had to tweak it here and there to suit French law. So it's not the same in every member state. This, for example, so as an umbrella organisation, we can't even say to all of our members, this is the way to do it, because we don't know what the situation is in each country either. And of course, and then our individual associations have members, and an association then has a different maybe level of compliance, or has to do it a different way with their application forms, with all the information they have about their members. So, but for the smaller, the freelance translators, it's definitely a financial burden we're finding, and we're hearing increasingly.
But how can you help them, you, FIT?
I think one way we think could be helped is if the Commission stepped in here and in the different member states offered some kind of workshop, for example, suitable for that member state, what has to be done. There are plenty of courses going on all over the place and have been for the last year or two. The solicitors or lawyers in the country are running courses for, God knows, for a lot of money, too much money, but they're not suited to what we actually do. So we need a tailor-made workshop. It doesn't have to be very long or over days, a few hours even, or a webinar or something that directly addresses our issues. I think would be a great help to a lot of the freelance translators.
Haro, are you making notes? Okay, good.
I just also would recommend, and maybe you as associations, you can also initiate drafting the codexes. This is one of the things, and also the obligations which goes from GDPR, that each industry should draft the codex that then has to be submitted to the European Board, which is the new regulator for the privacy, for the personal data protection. And it would also, will be very helpful, because that's going to be like a best practices set of rules. So if you submit them to the board for the approval, then you can create the best practices for your industry. And I think that you can cover all also, the smaller enterprises and also the freelancers. So if you can, this is one of the my recommendations.
All right. More hands. I would like to see where you are. There's one over there. Okay, and then Wojtek, you can start preparing a reply to the first question there on the slide.
Yes, I'm looking.
Okay, please.
Good afternoon. I have a question regarding machine translation again. If thinking about LSPs and freelance translators, if they are using a machine translation that is cloud-based, I mean, they don't have it internally in their own systems, and if the text that they are translating contain personal data, do they have to inform the data subject that they are using machine translation?
Yes. It's upon your responsibility as a translator what kind of tools you will be using. And I just also wanted to mention one article in GDPR which is very important for you who are using this, machine translation, because it really says the data subject shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her, or similarly significantly affects him or her. Which means, in practical words, that if you will be using just the machine translation without any other human being impact, I mean that you will really just leave it up to the tool, you are also breaching the GDPR, because, with respect that, the personal data are the subject of this, machine translation. Because we cannot allow algorithms, we cannot allow artificial intelligence or any, automatic machine processing just to make decisions, for example, or to, with respect to translation, to translate something which can, at the end will, that can harm me a lot, because, that would be, badly translated, wrongly, translated. So that's, also it has a very significant impact. So you are responsible for using the specific tool you are using. So what I would recommend is obviously to look at their website and just to, get assured that they have a privacy policy in place at least on the website, and you understand what they are doing with the data that, for example, are stored in cloud.
Okay, we can take a follow-up question from you, and then we go to the gentleman there. I'm sure you all already regret that you came to this session, because you're going to leave here not knowing what to do. Please, the follow-up question.
Thank you. Thank you for your answer. So if the process is not totally automatic, I mean, if we have machine translation with human intervention after, I mean, post-editing, then we're not falling into that specific article and we don't have to inform the client? I'm trying not to inform the client.
No, I mean, you have to inform, because in case that you are translating the personal data, obviously, if you will be translating my data, I have a right, according to GDPR, to know what you are doing, and basically where you store, for example, my data, whether they are secured.
So the only way is to remove all the personal data before having a machine translation.
Yes, exactly.
Okay, and just one more question. Taking into consideration what you said about DeepL, it's true that they have that strange clause saying that we cannot upload text that contain personal data. But imagine that DeepL changes the terms and conditions, and now they allow personal data to be uploaded in the texts, and that they enter into an agreement with us, the client, into a data agreement where they are data processors. Is it more secure to use than DeepL than another machine translation? I mean, if they have a data agreement saying what they do with the data, where they are based, to whom they are transmitted, etc., etc.
They are transparent. So, I just, they are transparent. They are fully transparent. So if you have a contract with them, I mean, the so-called processing, agreement according to GDPR, and you specifically determine who is responsible for what in terms of, the transmission of the data, archiving the data, then it's completely fine. It's just up to you, but still you are controller from the, data processing perspective. You are, their client. You are using, their tool. So you are responsible what kind of tools you will be using for your translation.
Thank you.
We'll take a quick comment, or can we go to the next question?
Yes, from my point of view, it all depends on the details of the contracts, of the documents. For now, from my point of view, in my opinion, DeepL is not a good solution for translating specialistic texts, including confidential data and personal data. And terms and conditions of DeepL are self-contradictory because on the one hand, they have this, as you said, strange clause that no text including personal data can be translated using their service. On the other hand, in the terms and conditions, they say that you should get their consent at all times. You are translating texts including confidential data or personal data.
Okay, let's leave DeepL for the moment. Sir.
Hello, Dragos Chovano from the University of Leeds. Initially, I was going to mention that apart from the personal data stored in the content itself, pretty much all CAT tools, all learning, language technologies that translators use also store the ID, the user names of the translators and also the revisers. So initially, I was going to ask what the panel thought that maybe LSPs need to do, whether it should be all anonymized, therefore losing this very important metadata for their use, or leave it as it is. But then, after you read the that paragraph very quickly, so I hope I haven't misunderstood it totally, I was also wondering, would GDPR be a means for the freelancer to get out of any potential follow-up lawsuits if the company decides to use a segment they translated in the past later on, and that text is then the subject of a lawsuit to the company? So can it be used in order to get out of such a situation so that the translator is not involved? Thank you.
It was a long question. I just tried to separate it in, maybe 2 or 3 pieces. The last one, if I just understood correctly what you were asking, is in case that you are a freelancer and you keep, the documents and translated documents with the personal data, whether you can be the subject of potential claim in case of some court proceedings. Did you mean this kind of situation?
Kind of the other way around. So I'm a translator, I translate the document, my ID is stored with every segment that I translate in the translation memory. Then the company receiving my translation and the translation memory reuses my translation later on without necessarily asking me. Maybe they gave the job to someone else even, and they didn't actually check that segment. Can I use GDPR to get out of any lawsuit because I wasn't actually consulted?
I think you should be at least informed, and this is the obligation of your client, that they are using your IDs. Because you are, from this perspective, as a freelancer, you are data subject from GDPR. So you have also the rights, according to GDPR, you have a right to know what they are doing with your personal data. And in case that your ID can be connected to you as a person, obviously your ID is your personal data. So you have to be informed by your client what they are just doing with and with whom they share, for example, your personal ID.
Right. We, like I said, is this working? Hello, is this? Yes, they run out of battery. All right. Like I said, we would be here to the next Olympics if we were going to go into more issues. But there are, most of the questions here on Slido are about intellectual property rights, copyrights. And the reply to the first question should be quite straightforward. And I'm sure you can give it in 20 seconds starting now.
No, I'm not. We should have a separate session for intellectual property rights in the translation industry. If you are interested in details, you can find my paper online, which was presented in Translating Europe workshops in May. But there is no straightforward regulation deciding who is legal owner of a translation memory. First thing to remember, the most important is that translation memory is a separate piece of intellectual property from the translation. It's separate.
It's a database, you could
yes,
say.
Yes, it is a database in the meaning of European regulations.
Yes. So the
Not
translation.
only it's from the technical point of view, it's a database, and it and it is protected by database regulations.
Yes. So there are several copyrights in a translation memory. First, the database itself is owned by the person who created that database. Then in that translation memory, you have your works. Like we said in the beginning, this is not data, it's works. It's your translation, and you are the owner of that. The original text has one owner. And then there is a fourth type of copyright, which is a sui generis right for certain databases. And there is actually the InfoSoc directive on a European level and the database directive where you can get some, this is the legal basis for this. So you have four kinds of copyright here.
So there is no one owner of...
no, there's not one owner,
and
unfortunately.
Bitcoin, no, sorry, not Bitcoin.
Don't start Bitcoin.
I mean, the blockchain technology could be the solution here. But it is
Yes, please. All right. I think that we are 2 minutes from time, and of course the most important duty of a chairperson is to make sure that the panel ends on time, so you can all get coffee, and I'm sure that there will be sweets too. So, or maybe not. No coffee and no sweets. Why am I doing this? I'm doing this for free. I was expecting coffee. Or do blockchain, who said that? Forget about it. All right, so I'm not going to take any more questions. I think that the conclusion from this session is that those of you who have companies to run or are work as freelancers, you need to learn more about how GDPR works. There is an article, is it 89 or 88, there in the end, telling how much money you will have to pay if you infringe it. And there's a maximum of 2 million euros, I think, or 4% of your turnover. So that's your incentive to be compliant. And here we see from the poll that 38% of you are not sure. Only 19% are sure. I think there's work to do. And I'm going to talk to the